Hi, my name is Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney. This video is called Subjective Features and is designed to assist legal practitioners appearing in the Local Court of New South Wales. I made a previous video called How to Plead Guilty, and in that video I explained my methodology for drafting submissions on sentence, and I emphasize that the most important part of those submissions is always the subjective features of the offender. The fact of the matter is that two men can commit exactly the same offence and come before the same judicial officer. One of them will be sent to prison and the other will be released without a conviction, and that all comes down to their subjective features, who they are as a human being. So if I may give an example using drink drive. Let's say that two men are stopped at a random breath test and both of them blow mid-range. They appear before the same magistrate. Now the first man has the worst possible set of subjective features. He has many prior convictions for drink drive. He has shown no remorse and has done nothing to rehabilitate himself. In fact, he comes to court and he says, "I did it, I'm glad I did it, and I'll do it again." Now, such a person is a danger to themselves and others, and they should be sent to prison in order to meet the purposes of sentencing. Now, the second man, on the other hand, he has been driving for 30 years and he has never come to the notice of police. He is the man who has suffered an extraordinary event. For example, he saw a co-worker killed in an industrial accident, let's say, and he was traumatized by that event. He had a few drinks to calm his nerves, and then he made a very bad decision to drive his car. Well, he's stopped by police, he makes full admission, shows immediate remorse, and since the offending, he hasn't had a drink, but he has been going to counselling to deal with the stress of this adverse event. In addition, he says to the magistrate that he needs his driver's license for employment and he's the breadwinner for his family. Well, most people would agree that he should be discharged without a conviction because he requires no more punishment in order to meet the purposes of sentencing. Now, you've heard me mention the purpose of sentencing a couple of times in this video. The purposes of sentencing are found in Section 3, capital A of the Crime Sentencing Procedure Act. There are 7 purposes of sentencing, and every defence lawyer should know all of them by heart. When you make your submissions, you are expected to refer to all 7 of them. Now, the magistrate does not want to hear your client's entire life story. It is your job to hear your client's entire life story from the time they were born, everything that's happened to them, what happened to them at school, what was their family situation, what is their employment history, what is their medical and mental health situation. And then once you've heard everything there is to know, you can then determine what is relevant to those 7 purposes of sentencing. Now, this can be quite an intrusive experience for the client, and you should tell them up front that you're about to ask them a whole lot of intrusive questions, and everything that they say to you is both confidential and privileged. Once you have that information, you will then decide what material is relevant to put before a magistrate. So, the 7 purposes of sentencing are, firstly, to punish the offender. So you should have some information to put to the magistrate to explain why no further punishment is necessary for your particular client. The second purpose of sentencing is to prevent and deter crime, both by your client and by other people in the community. So you should have some information so that you can make the submission that no further deterrence is required. The third purpose of sentencing is to protect the community. So you should have some information for the magistrate to explain why your client is not a danger to the community. The fourth purpose of sentencing is to promote the rehabilitation of the offender. And you should always have some information and ideally some evidence to show that your client is enthusiastically engaged in rehabilitation, whether that be counselling or the traffic offenders program or anger management or anything at all. The fifth purpose of sentencing is to make the offender accountable for their actions. And in those circumstances, if your client has provided an apology and compensation to the victim of the crime, that always helps. The sixth purpose of sentencing is to denounce the conduct of the offender, and this is usually not necessary if your client has apologized and written a letter of apology to the court, acknowledging that they did the wrong thing and promising not to do it again. And the final purpose of sentencing is to recognize the harm done to the victim and to the community. So you should be obtaining information and evidence in support of that information that is relevant to all 7 of those purposes. It can be the difference between them going to prison or not going to prison, or it can be used to reduce the number of hours of community service or the amount of a fine, or in some circumstances it means that your client can avoid a conviction altogether. Thank you for your attention.